Hello, everybody. It's Ernie, and I am happy to be back. It's been a little bit, a couple of weeks while we were out on vacation. We are back and ready to talk about landlording again. So I would like to just dive right in. We're going to wait a little bit for a few more people to join, but today's topic has everything to do with that precarious situation where you might find yourself a little bit stuck because your tenant's gone and they still owe you money, and you want to know what you can do to, put yourself in a better position than being left out in the cold once your tenant has vacated. And so I want to, welcome those of you who are joining live and let you know that if you have a question that you want to add, go ahead and add that in the chat. I've got a ton of questions from our Facebook group. If you're not a member of our Facebook group, I do welcome you to join that, particularly if you are from Texas. It's called Texas Landlords, and it's landlords from all over the state, some even from out of the state, who own property in Texas, who have questions and want to, get together with other landlords in Texas to ask, who's a good plumber, who's a good roofer, who's a good property manager, who's a good insurance agent for things like this. A wealth of knowledge in that group. It doesn't just come from me. We've got over 8,000 landlords that are members of our group and actively answering each other's questions and helping each other out, sharing that collective knowledge. All right, we have Adelbenz Albernews. Good afternoon. Thank you for your assistance. You're very welcome. Good afternoon to you too. Looking forward to today's topic. So again, we're talking about what you can do when your tenants left the property still owing you money, which is always a bummer. And you're not going to hear the best news, but you are going to hear what you need to hear in order to best prepare for the situation, because it does happen. I'm going to start off with the worst. Sometimes you can do absolutely nothing. Sometimes you've got what we call in the business a judgment-proof tenant. And that judgment-proof tenant simply cannot be touched. They're not going to have enough money ever to pay back the debt that they left. And so you've just picked up a very expensive life lesson, having to deal with somebody who has zero capacity to pay you anything. And so if you're stuck with a judgment-proof tenant from the beginning, if you know that problems are being called, these are the ones you got to get out the quickest. And you don't give them the opportunity. We're going to talk about prevention. You don't give them the opportunity to put you in a hole. You want to move on from these guys and really seek to lease to a different kind of tenant that isn't going to put you in this position. But a judgment-proof tenant is someone you could have a $10,000, a $100,000 judgment against them. There's absolutely nothing you can do to recover it. We have Asinha Badil says, hello, Ernie. I have a contract that's ending this month, July 31st, 2025. I signed the renewal back in January, but the situation in the apartment got very, very bad. We saw a snake, a lot of spiders, and my daughter. We informed the landlord we will not move in and honor the new lease back in April. So that sounds like a problem. If you've got an issue with your landlord and there's a defect, I don't know if you're in the state of Texas or not, but the requirement in the state of Texas is if you've got an issue, the tenant is required to send written notice to the landlord and give the landlord a reasonable opportunity to deal with this. I signed the renewal back in January, but the situation in the apartment got very bad. We saw a snake. So I don't know if you're speaking from a landlord or a tenant perspective. Gave 4 months. Well, if a landlord has failed to act within a reasonable amount of time, the Texas Property Code, I see you are the tenant. The Texas Property Code does give you an option for terminating the lease if you have followed the steps. Again, I don't know if you're in Texas or not. If you do want to talk more about this case from a Texas tenant perspective, I'm certain we can do that. But for now, I would say notice is essential, and then following the property code. If you are demanding that the contract be terminated, you can prove that you sent the proper notice, and then you can prove that you sent a notice that you will terminate if the landlord fails to conduct that repair within a reasonable amount of times. Those are pretty much the rules, whether the landlord favors it or not. If you can prove that you gave the proper notice, and if you can prove that there is a defect that materially affects the health and safety of an ordinary tenant, again, it's all about notice and giving the landlord a reasonable amount of time to repair. If they are unreasonable, then again, in the state of Texas, there is a mechanism to unilaterally terminate the lease and walk. So that is entirely possible. But moving on with today's topic, thank you, by the way, for contributing. Again, anybody who wants to ask questions through the chat, we're happy to answer those questions. So if you've got a judgment-proof tenant, that's not going to help. One other thing that sometimes landlords try to do that I don't recommend is to want to rant and rave and talk about this terrible tenant who left owing money. The last thing you want to do is to publicly disclose that any individual owes you an unpaid debt. That violates consumer protection laws, and so just don't do it. If you want to speak in generic terms or anonymously, that's a whole different subject. But don't ever call somebody out and spread their business, particularly from a debt that is owed. You don't want to put yourself into trouble by disclosing the unpaid debts of a third party. That kind of opens the door to litigation to you, and it just doesn't help. It just makes things worse. So Roke Spear says, use a performance bond if you really want to be secure. And I don't know about that in the state of Texas, but if that works where you are, that's good. I see James coming back. Hello, Ernie. Welcome back. James, it's great to be back. I always enjoy seeing you here. You're here like 1,000% of the time, and I appreciate that very much. So what can you do if you see things going down a path where you think, this guy might just hang me out to dry? There's a few things you can do during the lease term that'll actually prevent this very thing from happening. And if you're not doing these things, you're the most susceptible to a tenant just walking out owing you money. So get ahead of it and prevent it. The first way to do it is with an inspection. If you are routinely inspecting your property, you are the least likely to be hit with some surprise problem, 2.5, 3 years into the tenancy. If you're not inspecting your property, you can expect some damage, some major overhaul work that you're going to have to do because you gave 100% authority to that tenant, and you were never in there to call them on it. And really, that's the second point. As soon as you see that the tenant has broken something in excess of normal use or in excess of ordinary wear and tear, for example, the classic one is the dog. That dog goes and scratches up the door. That dog is chewing on the stairs, or the cat has gone and just totally dismantled the blinds and made a mess. You're recommended to do the following. You get in there, you issue a notice to vacate, you make the repair, and then you issue a bill to that tenant and say, look, I'm going to be in here routinely to make sure that this house is well maintained. If you or your pets or your kids or your friends or your neighbors, anybody associated with you, if you guys are tearing up the place, I'm going to repair it, but I'm going to charge you for it. And you might have, you might experience some hostility. That's somebody you want to start working on getting out quickly, because if they're being hostile about repairs to your property during the tenancy while they're at risk of eviction, you better believe that toward the end of the tenancy, they're not going to care a whole lot because the risk is gone. So you want to be able to utilize the power of the courts in a way that maintains your property in the highest state of repair. If they're messing something up, you go in there, repair it, and then send them a bill. And if they refuse to pay, then you send them a notice to vacate and get rid of them. I mean, that's just simple. We always preach a 3 strikes and you're out. If they've got multiple times where they've been notified about getting stuff done that they just don't get done in violation of the lease, notice, and then a notice to vacate to get them out. So you're inspecting, you're making repairs and billing your tenant, and then finally you're evicting faster. Don't wait. Don't have in your mind, well, I'd rather just avoid the trouble of eviction than evict somebody who I know is going to cost me money, who I know is damaging my property, who I know is going to pose a problem. You send that notice to vacate when you are at the point where you are certain this is no longer going to work, right? If you send a notice to somebody and they fix it, no big deal. But if you're sending notice after notice after notice and nothing gets better, that's a big deal, and you got to get rid of them. If you can see, for example, here's a classic one. After the first 3 months of your lease, first 90 days, I recommend that you're on the property. You're on the property after the first 3 months, because if they're already messing things up, that's a big you got to get rid of this tenant. One key factor, take a look at that filter, the AC filter. If you take a look at it and it's filthy, that means they haven't changed it in 3 months. And so you want to make sure that you've told them ahead of time, look, I'm going to come in and I'm going to do an inspection. Please make sure you're keeping up the simple stuff. Change the AC filter. Keep the house in good working order. Don't let the kids leave a bunch of toys outside. All of these things violate the lease. And if you're there and you got to go and you got to change the AC filter, you're going to issue a notice of default, because that's something they should be doing. And if you reminded them ahead of time and it's clearly in your lease, hopefully this one time that you're issuing that notice is the last time you'll ever have to do it. But if it turns out that when you come back 6 months later, because I recommend visit them after 3 months and after 9 months, and you come back 6 months later and it's the same filter you put in 6 months ago, that's a terrible sign. But by you taking care of things and by you inspecting it and you ultimately evicting a bad tenant, you're going to protect your most valuable asset, which is that rent house. So make sure that you're on top of it, always taking care. Now, either A, you do those things and somehow they still mess something up, right? And they walk away and you want to come after them. Or you didn't do any of these things and absolutely they messed things up. They left you with a big repair bill. What do? You got to think of 2 things. The first thing is, can you find your tenant after they've left? If you can't locate them, you can't sue them. So being able to identify where they are is key. Now, you may not know where they live, and many of you might actually, especially if they're local and you know, maybe they even told you where they're going. If they want a forwarding, if they leave you a forwarding address, they might give you the address of where they're headed next. But if you know where they work, you can sue them. You can serve them with notice of a lawsuit if you know where they work. But if you don't know where they work and you don't know where they live, if you don't even know if they're still in the same state, suing them might not be worth it. Now, there are methods that you can employ to find people. We do it all the time. And they're going to cost a little extra money. And if your lawsuit is worth it, then I would say, yeah, spend a little extra money, locate them, serve them, sue them, and get your judgment. Remember we talked about the judgment-proof tenant? If they're one of those, it's just not worth it. Even if you can locate them, you got to ask yourself, do they have the capacity? This is the second question. Can I find them, and do they have the capacity to actually pay? If they're judgment-proof, just forget it. It's an expensive life lesson. Move on. But if they have the capacity to pay because they have good earning capacity, or they own property, or they have a healthy bank account, and you know of these things, maybe they did things just to spite you, right? They didn't pay that last month rent because they're like, whatever, I don't trust you, I don't believe you, I'm not going to follow your lease, I'm out of here early. And so you lost out on a substantial amount of money from somebody who has the capacity to pay. So you've got a couple of ways of dealing with this former tenant. You could start off with a demand letter and say, look, you breached the lease, you caused X in damage to me. I'm going to give you a reasonable amount of time to come up with the money to pay this. But if you haven't paid it within 30 days, say, or worked out some kind of payment agreement with me within 30 days, I'm going to go to the courthouse. Your notice might be shorter. It might be 10 days. You might say, look, I'm coming after you unless we work this out in the next 10 days. I'm ready to head to the courtroom. And maybe that's a bluff. Maybe it's for real. I don't ever recommend talking about a potential for lawsuit unless you're actually ready to pull that trigger. But let's say you're just bluffing, but it works. And they contact you and you work something out. And maybe you don't collect everything, but maybe you collect 50%. That's your agreement. And so you've gotten some of it back. And that's always helpful. The other is the lawsuit. So you maybe sent the demand letter, maybe you went straight to the courthouse, but in any case, you've decided you're going to go the route of a lawsuit. So under a certain amount, you probably get away with going to the small claims court. In Texas, the Justice of the Peace has jurisdiction up to $20,000. The county and the district courts are there for everything else. So we recommend that, particularly if you're going to, do this on your own, you can do it through the justice court, but if they hire counsel, then you probably want to consider hiring your own attorney. But this is definitely something you can present at court. And if you've got all the right evidence and you have all your receipts and all the proof of the damage caused by the tenant, you should prevail. However, we always recommend that you seek out legal counsel to understand how to present your evidence and really kind of to decipher fact from fiction, because in certain instances, you might have receipts for things, but that's not what courts are looking for, or these are not the kinds of damages that the courts are willing to award. So to get that straight, it could be helpful for you, even if you're going to go at it alone, to have at least a consultation with an attorney to sift through your data and kind of give you a few pointers. We do that for clients all the time. But if you go to trial and you win with counsel or without, the next thing you should do in the state of Texas is to secure what's called an abstract of judgment, and then after that, a writ of execution. If you know that people have the capacity to pay, and they've either got accounts with sufficient funds in those accounts, or they have real property or personal property that is not otherwise exempt from collection, then those things can be used to pay off your judgment. For example, if you're suing somebody who owns a piece of property with, say, a sibling, so they've got their house and their primary residence in the state of Texas is protected, but they own another property that was inherited with a sibling. Guess what? That property is subject to seizure. And through a writ of execution can be seized by the constables and can go on a constable sale, and any funds collected from that constable sale will be applied to your judgment. Just the same if an individual has a single vehicle, but then 2 or 3 other vehicles, guess what? Those extra vehicles are subject to seizure, and the constable can, for vehicles registered in a given county, go and seize those vehicles and sell them at auction, and those proceeds get applied to your judgment balance. Finally, if someone has an account, some kind of banking account that you know of, what's that institution? What's that account number? You can actually attach the judgment to that account, seize the funds that are in it, and have those applied to your judgment. These are not simple tasks, and so you're likelier to need the assistance of an attorney to get these done. But if you have a tenant who has left owing you money and they've got assets that can be seized to apply to that judgment, of course, I strongly recommend that at the very least, you send a demand letter saying, this is where I'm headed. And if they respond, great. And if they don't, file in the courthouse, get your judgment, file your abstract, and seek to collect through a writ of execution. So a few things for you to consider. I know, the best medicine for you is to learn these preventive measures. And this is what I always emphasize to landlords, because it's much easier to save your money from loss than it is to recover your money after the loss. And so I urge you, all of you, inspect, make repairs, and evict faster. Those, I think, are the most important keys. So we're about to jump into our previously submitted questions. I'm looking forward to answering all of your questions. I see that a few more of you have chimed in. War Clan says, if a tenant owes money and you take them to court, What would be the general expenses for that? For Texas, how can we report a bad tenant to make people aware they are bad people? Well, I don't tend to make judgments like that on the character of an individual. Certainly a bad tenant might be a bad fit in one situation and a perfectly fine fit somewhere else. But throughout the country, since 2018, judgments are no longer on a person's credit report, which is one less arrow in your quiver. But a judgment lien, which I've talked about by abstracting your judgment in the state of Texas, is a findable thing that creditors find, particularly if somebody's buying a house or they're looking for financing for a vehicle. These judgment liens are out there and pose a threat to the collateral in question. So a lender might tell somebody like a tenant who's got a judgment lien on them, hey, you got to get rid of this judgment before I'm going to loan you the money for the purchase of this vehicle or the purchase of this house. And that's when I get a phone call, say, hey, what do we got to do to release this lien? I got somebody here who wants to purchase a vehicle or purchase a home. That's when I contact you. We talk about the procedures. I tell them X is what the judgment is now worth because they grow with interest over time. We collect the funds. I send the funds to you. I send a release of judgment. Bada bing, bada boom. Again, that's in those situations where you have somebody who's got something to lose by keeping that judgment in their name. So always, 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 if there's a person with the capacity to pay, you abstract that judgment. In terms of costs, if you do this on your own, the filing fees can be under $200. And so, $200 to $300, depending on how many defendants are involved. But, if you go through the small claims court, again, your claim is under $20,000 in the state of Texas. It's actually pretty manageable. What you're talking about then, the cost associated would be time. And do you know how to present your evidence? Do you know how to, draft a proper petition? And are you doing the maximum you can to recover the most impactful judgment? In that sense, you might incur a little more cost to go and speak to an attorney, if not for representation, then maybe for a little guidance to that judgment. So that's for War Clan. Asinha Badil says, what is the best course of action if we don't move in to the apartment? New lease starts 8/1/25. I cannot let my kid in an apartment with snakes and spiders. A new lease has not started yet. So this is really hard, Asina, for me to really say. I don't know the particulars. Certainly, if there is a defect, I would issue notice regarding these pests that are in the apartment. If you've got a whole month before this, and again, I'm a little confused about the facts, but if you're saying right now the place where you're staying, there's a defect that materially affects the health and safety of an ordinary tenant, and you've issued notice, then you should issue another notice saying, look, I've previously issued notice to you in writing. Here's my next notice in writing. At least this is the way it works in Texas. If you fail to remedy this problem within 7 days, I'm just going to cancel the lease. A good landlord's going to respond to that. And I don't know what procedures you followed so far, but if you give a landlord a reasonable amount of time with notice in writing, they have a duty to respond. James says, I own a vacant lot with a construction business next door. They are constantly parking their vehicles on my property. I've tried being nice, but they continue to park there. Any suggestions? Well, you can tow vehicles that are on your property that don't belong to you, that are there without your permission. So that's one potential option, but we know that they're not abandoned. The other is you can sue them. You can send a demand letter and say, look, you are trespassing on my property. If you continue to do this, I'm going to sue you in court for money damages for this. And you just come up with whatever number you believe is suitable for the harm that they're causing you, and let the judge decide whether that's fair. And so just like with tenants, I would say make sure you establish a paper trail. Send a written notice demanding that they stop doing it. It's what we refer to as a cease and desist. And if they don't, send another one and another one. And you can use the same 3 strikes policy that I recommend for landlords because multiples are always good for the court. They don't always go for it on one instance. But if you've got multiple instances in writing where they do nothing in response except violate, then yeah, go ahead and hit them with a lawsuit and an injunction. And what an injunction is an order from the court saying you cannot do this anymore. If you violate that order, now you're subject even to as high as criminal penalties, which is not common, but if you put a permanent injunction in place, stopping them from ever parking there without your express permission, that could really go a long way. I doubt that it would have to go that far. But you may sue them for example, having to put up a fence to prevent them from parking if after written notice, they simply don't comply. So let's go ahead and go on to the first question from Facebook. This comes from Diane Samrad Eberhardt, who writes, can a tenant refuse entry if she is home and says it's because she's working from home? So, as always, and is usually the case with these kinds of questions, what does your lease say? It's going to depend very heavily on what your lease says. If your lease says you can enter, even for an inspection, even without sending them written notice, then no, the tenant cannot do that, technically speaking. So let me explain what I mean. So in Texas, and again, I'm not speaking for everywhere around the world, but in Texas, the landlord does not have an absolute right to enter property. But a landlord can enter property under three conditions. Number one, that the basis for the entry is reasonable. Okay, so in this instance, I don't know what the reason is for entry. Let's assume it's for an inspection. Reasonable. Number two, that the time or that the manner in which the landlord enters is itself reasonable. So number one, do you have a good basis to do it? And are you going at a good time? So just because you've got a good basis and inspection, it doesn't mean you can go at 9 p.m. And expect to be warmly welcomed. That's probably not reasonable. So a reasonable basis, a reasonable time. And the final one is in a peaceful manner. Now, this one is a two-way street though, because, and really they all are, because reasonable is relative to the situation, which includes your tenant. And I'm gonna talk about a scenario in just a second. But let's say you go to inspect and you go at 12 noon. And you enter peacefully. You knock, nobody answers the door, you happen to have a key, so you use your key and you get in. And you hear the, what are you doing? Get out of my house. That's no longer a peaceful situation. In fact, the moment the peace is broken, even by the tenant, you no longer have the right to stay. So generally speaking, yes, even if your lease says, well, you got to give a 24-hour notice. Well, that goes to the element of the reasonableness. Did you give the notice? Then it's reasonable for you to come in. But generally speaking, leases don't, even those that require notice, do not require that you get additional permission from the tenant. But you got to meet all three of the standards. Is there a reasonable basis? Is it at a reasonable time? And is it in a peaceful manner? And if even the tenant breaks the peace, you cannot enter. That doesn't mean that isn't a violation of the lease, because if you were otherwise entitled to go under the terms of the lease agreement, I would issue a notice of default and say, look, I followed the lease. You failed to follow the lease by preventing me to come in. I'm going to come back next week at the exact same time. I'm going to be there at noon on Thursday. Please be ready for that. I need to inspect. And you show up and they do the same thing and you issue another notice. And in that second notice, I would say, look, if I do this again and you fail to allow me in, although it is my right under this section of the lease, I will then issue a notice to vacate. And sure enough, you go back the following week, and sure enough, they bar the door. Don't just stand for that. Issue that notice to vacate and move on. Okay, Alexander Valentin says, in a typical Texas lease, if a garbage disposal jams because a tenant accidentally drops something inside, it is generally the tenant's responsibility of the tenant to fix it? And if they try to fix it themselves and either damage the disposal or get hurt in the process, is that still considered their responsibility under the lease? Also, could I be held liable or even sued if they get hurt while attempting the repair, especially if I sent them a YouTube video to guide them? My tenant recently called out about a jammed disposal, so I sent him a YouTube video showing how to remove the object. He was able to fix it, but it got me thinking, it got me thinking about the what if scenarios. Curious about how you would handle this. Number one, I would never advise you to have a tenant conduct their own repair because of the risk, right? Let's say somebody says, oh, I've done it a million times. Can I install a ceiling fan? It's a simple loop, 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 loop. But what if? What if something went wrong and they got you in writing agreeing, sure, you can do that. But they don't know that the wiring in your house is somehow magically different than the wiring in every other house. And boom, not only do they get injured, but they die. Yeah, you could be seeing some liability for that because I don't think indemnity will work here, even though your lease may say you're indemnified for acts that they caused, because essentially they were functioning as your agent at the time. They had your permission to work on your house. I just wouldn't do it. I'd put it in the hands of a contractor. I put it in your own hands. I would not advise the tenant to do something even seemingly dangerous. Anything having to do with electricity, the garbage disposal, there's always a risk. And so you might be saying, but Ernie, the risk is so small. Yeah, well, that's what we're talking about, is if there is a small risk of harm, that's still a risk. And you have to decide whether or not you're willing to assume the liability for that small or larger risk. In this scenario, yeah, if you authorize it, then you've kind of assumed a degree of risk. If they tell you, hey, there's something wrong, I don't know what to do, then the best bet is for you to just handle it yourself. Get your own handyman or show up yourself, take care of the problem, and eliminate that aspect of risk. And when it comes to repairs, I tend to disadvise landlords from having the tenants do the repairs themselves. I just don't think it's a good idea. I think along with the risk of them injuring themselves, you have the risk of them doing a crappy job. And so, not super in favor of that as an option. So we see Sinha. We emailed them about the snakes and spiders. They say we took care of it, but I still have them, the same problems. I have pictures. Again, Sinha, I think what you might need is an actual consultation with an attorney who represents clients in your local jurisdiction. We can go back and forth here. I don't know that I'm going to be super helpful because I can't review any of your communication. What I would say is that Texas law requires 2 written notices. One, letting them know that the problem is there. And if they didn't remedy the problem, the second one, where you elect a remedy. And if you mean to unilaterally terminate this lease, you got to send that written notice. Now, whether notice by email is sufficient under the terms of your lease, again, I'd have to read your lease to know if that's proper communication or not. And I don't know that I could even do that depending on where you are located. In any case, I do wish you the best of luck. I just don't know that I'll be able to help you in the chat going back and forth like this. James says, thanks. James, you're welcome. So I'm going to move on. Jordan Neufeld asks, if a neighbor wants to buy a piece of my property, how do I go about asking the mortgage company to release or a partial release of the lien? Well, first off, you don't. Your lien with a mortgage company is an independent agreement. You're going to owe all of it no matter what you do with your property. And so unless the person buying a portion of your property is also paying off a portion of the mortgage, the simple part is, well, you send that over to them. The more complicated issue is, if you got a piece of property and the county recognizes it as one unit, but you want to subdivide it, well, you got to have county approval for that. And so without that, it's still just the whole property. And so you can't just arbitrarily cut out a piece. The county would have to approve it. Maybe it's a neighbor and it's a neighbor and they want to, increase the size of theirs and decrease the size of yours. You talk to, somebody at your county about how those boundaries can be reassigned and reassessed. That's a possibility, but it's going to have zero effect on your loan. Laura Valdez writes, my expenses have gone up since a tenant moved in. Property taxes have increased, and I had to purchase a new AC. Do I have to wait until renewal time to increase the rent, or can I do that during the lease? The lease contract locks in the price. Yeah, Laura, I think you know the answer to this. If you're locked into a term, you cannot make any adjustments unless they agree to the adjustment. So any lease can be modified by all the original people who signed that lease. It can't be done by just one. So if the landlord says yes and the tenant says no, there is no change, no modification. I mean, the same would be true if the tenant said, you know what, I think I want to unilaterally lower the rent. That doesn't happen unless you approve of that. And sometimes that happens, not often. But no, you can't change the lease during a set lease term. So it would have to be at renewal. Misty Gilbert writes, do you have any special recommendations that we as landlords leave for our executor of the will with regard to rental properties? This is a bit ambiguous, but in terms of, management of rental properties, it's really going to depend on how those rental properties are held and whether they're already managed by a property manager, and then who gets them. Right, so there's a lot of unanswered questions here that would require different answers in each of the different scenarios. Assuming that you have, for example, a management company, Rental Properties LLC, that conducts the business of the rental management, and the properties are owned, let's say, in your individual capacity. And you're deeding all your properties to your favorite nephew. And so, well, your executor, and now we got to talk about your LLC, how is that going to go? Well, that's subject to its own operating agreement. So that's not really handled by your will necessarily. It should have contingencies for your death. Or contingencies for the surviving members. So then this gets really complicated. I want to do my best to answer this question, but there is no one size fits all scenario for the facts in this particular question. All right. So I've seen how you're in Houston. Okay. Well, again, I recommend you reaching out to the office if you're interested in talking with a licensed attorney for an apartment or landlord-tenant matter in Houston. My contact information is all over this all over this YouTube channel. Feel free to give us a call. We'll be happy to consult with you. Darren Gillespie says, sorry for joining late. Darren, no problem. You're cool. You're welcome to join whenever you want. You can also watch the replay if you missed the first part. That'll be up soon. James E. says, I have an elderly tenant who may have dementia. I do have an emergency contact for the tenant, but I cannot get a hold of that contact. What should I do? Well, these situations can be complicated. But if it's the only tenant and they signed and maybe rent stops getting paid and you got to move forward with an eviction, if you have someone who's elderly and maybe they're not being cared for, you might have to call Adult Protective Services in on this, especially if they're the only tenant. If they don't have an adequate caregiver and things have kind of gone off the rails in terms of the way they're handling their own tenancy, that might be where I would go. Adult Protective Services, and that's the only thing I can really think of in terms of their protection. But in terms of you, I mean, if the rent's not getting paid, You got to follow the normal procedure for eviction, and that's an unfortunate situation. Alexander Valentin writes, thanks for the great advice about the garbage disposal. It was just a bottle cap. I had no future issues myself. Great tip. I'm glad it worked out. Yeah, sometimes just a simple magnet gets that stuff out. Although I guess it would stick to everything else. It was just a magnet. Who knows? Darren writes, I was wondering if you answered the question posed on your Facebook group post for the investors in Dallas-Fort Worth. I'm not all the way down the list, hopefully. In fact, Darren, I see your question coming up. So you're 2 questions ahead. So no, you didn't miss it. And then Royman Verroes, saludos a todos desde Dallas. Hey, well, welcome all of you people from Dallas. Here we go. Next question. Liliana Castillo writes, when renewing leases, how much can you increase security deposits each year? If you never have increased it and it's been years since the initial lease, can it be a larger amount? In Texas, there is zero cap on how high your rent can go at renewal or how high your security deposit can go at renewal. The truth is, if you're renewing, the tenant does not have to agree to the higher rent or the higher security deposit. So no, there's no restriction in a Texas lease as to just how high you can go. If they're willing to pay it and that's your limit, then by all means raise that amount. If they're not willing to pay, you simply can't force them, but they can't stay. And so if you properly terminate the first lease and say any subsequent lease will be part of a higher rent or higher security deposit or both, and they don't agree, then they gotta go. Very simple. All right, so Darren Gillespie, my current tenant has been late several months in a row. I have given them notices and warnings. They are participants in the Tarrant County Housing Program. I've already discussed this with them. If I need to evict them, what steps do I need to follow? In Tennessee, I have a person that files and serves for me, and then I have to show up to court. Is there a similar process here in Texas? So just to be clear, it sounds like the Tarrant County Housing Program is a HUD program where you're receiving federal funding. Let me know if that's true, Darren, because if it is, then there's a couple of things. So in Texas, what you're going to want to do is, number one, give a notice to vacate if you're looking to start the eviction process. But don't just give it to the tenant. It is necessary, probably part of, I got your yes there, very good, probably part of your HUD contract to send notice also to their liaison. There's probably a contact person there in the Tarrant County Housing Program who you should simultaneously send notice to as well. So if you're sending a notice to vacate, send it to both the tenant and to them. Wait out your 30 days because you're subject to the CARES Act, which gives you a 30-day requirement because of the acceptance of the federal funding, and then proceed to your eviction if they haven't moved out within that 30 days. So that's, whenever you're accepting federal funds, that's the one difference. You're definitely subject to the 30-day notice to vacate, but contact that liaison, whoever your contact person is for the housing program, and then proceed with your eviction. If you don't contact them, it's a technical violation of your agreement with HUD, and sometimes defendants use that as a means, particularly if they have a pro bono attorney, as a means to defeat your eviction. Darren, you're very welcome. Let's see, Tiger Harris writes, what happens if a tenant has fake lease paying rent to a fraudster? Do they have rights as a tenant? Well, it depends who committed the fraud, right? So if a tenant, and this happens, you've got a vacant property, somebody comes up and says, hey, I'm leasing this property from Joe Bag of Donuts, and I pay him the rent every month. I've been here for a month and a half. So we don't know exactly who's committing the fraud, but they've got a lease and they've got receipts that show they paid first month and a deposit and they've paid a second month. And so you show up and say, look, well, Joe Bag of Donuts is not the owner. I'm the owner. Here's a copy of my deed. Stop paying this, and you've got 30 days to get out. And so the tenant's going to fight and say, no, I've got a valid lease, when you know that they don't. And so by giving them a notice, because again, you're not in privity with them, Now, you could decide, well, if you sign my lease, I'll keep you. Probably not a good idea because chances are very high they're in on the fraud. So I would give them a notice to vacate and get them out. Now, they're not technically squatters at this point because they entered through what could theoretically be a seemingly legal process. They thought they were leasing from an individual who they believed to have had the legal right to lease to them. And they are in possession and they have established tenancy. And so the question for you is, how do you get rid of them? You got to issue a notice to vacate. In this case, it could be 3 days, it could be 30 days. The fact that they can prove that they paid rent to a third party could complicate things, which is why I would say 30 days. And so to kind of get around all that, you give a 30-day notice to vacate and get rid of them. Now, if they can't produce who this fraudster is, then it kind of breaks down the narrative. And so these kinds of cases are very fact specific. But yes, this kind of fraud, unfortunately, is becoming more and more prevalent. Let's see, Monica Hearn says, can a tax credit property and Section 8 security deposit be written in after I signed and moved in? Can a tax credit property, Section 8 security deposit be written in after I sign? I mean, generally speaking, an original lease cannot be modified afterward unless all the parties agreed. So I would have to know what was originally signed and what subsequently was proposed. But yeah, I mean, things can be modified after the fact as long as all the original parties to the original agreement sign the modification. And so without knowing exactly where things are, I'm not super sure how to answer that question for you, Monica. James says, curious how they got the keys. Yeah, it's a good question. A lot of times what happens is whether it's the occupants or the fraudster landlord, the locks are drilled and the keys are changed. And so the tenant can always say, well, it must have been the fake landlord, who again is never going to appear anywhere. And it's hard to prove, which is why I recommend all sorts of things when you've got vacant property, including keeping a ring cam on the door that you have access to so you can see who's coming in and who's walking up with a drill. That's one thing. But also, deputize your neighbors. That's another way to keep your property safe whenever it is vacant for some time. And there are other tips. I've got other videos on the subject. Tiger Harris writes, 30-day notice is always safest. Thank you. Monica writes, and it was overcharged. Well, yeah, and so I'd have to know more. They had me apply for a Rhino program, which was a security deposit insurance, but I didn't get approved. I would need to know more of the facts of the original agreement and whether this was proper. But if you signed an agreement and now things are kind of not working out, I need to know much more about the actual documents that were signed. Kind of sounds like things got jammed up. Let's move on. We got plenty more questions. Teresa Danielle Lynn Hazard writes, I need information on evicting someone who was renting out an RV to, and they have parked it on private property, and I cannot get the notice served. How to fill out the writ of possession paperwork to give to the judge because it is not her physical address, it's a mobile unit. Okay, so I'm a little confused on some of these facts. How do you evict someone who was renting out an RV to, they parked it on a private property? So here's the thing. If you were renting the vehicle, that's different than renting real property. So it would be like renting a car, and it would not be subject to the Chapter 92 eviction process. So in that essence, or in that scenario, it's probably more like a repossession. Now, what your rights of repossession are, couldn't tell you. And I don't know what kind of agreement you signed, but generally speaking, eviction pertains to real property. And so if you, for example, leased a lot where an RV was parked, then that lot is what's subject to the property code, because that's the real property that you are leasing. And if they move their RV, well, then you've got possession back of your rental lot. If this was your RV in a rental lot and they drove it off, that sounds like theft of a vehicle. And so that's a criminal act. But if you rented the RV to them and said, you can park it wherever you want, and now you're having trouble collecting, that's a rental agreement like a car rental. And again, it's subject to just a different area of the law. So I'm not sure that I can help you on this one, Teresa. Number 9, Alexander Valentin writes, have you noticed an increase or decrease in tenants leaving rental properties while still owing rent in recent months? Yes, my entire practice. And I guess the reason the number has increased is because the number of landlords that I've served has also increased over time. But yeah, this has not gotten, I don't know that it's gotten significantly worse. According to November 2024 Consumer Financial Protection Bureau, about 2.8% of U.S. renters had outstanding rent balances, down from 6% in 23. In Texas specifically, there are approximately 4 million renters or renter households. Nearly 37% of Texans rent their home. Based on the experience, do these national and state level trends of rent delinquencies reflect, are you seeing in Texas? Are there more tenants moving out, still owing rent, or is the situation improving locally? I can't say that there's been necessarily an upswell, anything other than what is routine. What is occurring is that costs are going up. So the amounts of judgments I have noticed are going up, but that's mostly because the values of rents are going up, and rent values are going up because property taxes are going up. And so are you asking, have I seen the effect of inflation? Yes. Do I believe that proportionally, tenants are getting significantly worse? No, not necessarily. I'm still seeing the same kinds of behaviors. What I hope to reverse are the behaviors of landlords and teach them how to prevent these kinds of things from really getting out of hand. And you guys who are here are learning those things absolutely. And so I applaud all of you for joining us. Number 10, Betsandra Garcia Hamilton writes, if the tenant has assets like fourplex houses and cars, how can we collect money after getting a judgment? We got an abstract that was filed in the county, but the tenant didn't use the title company and just passed ownership of one of his properties to avoid foreclosure. The tenant still owns 4 more properties and 2 cars. Well, if that tenant owns them in their name and you have a judgment in their name, like I mentioned before, you get an abstract of judgment to create a judgment lien. You record that in the county where the real property, the non-exempt real property, is otherwise deeded. Same property clerk record where their title is held, put it in there. Then you ask the court for a writ of execution. The county will then seize that property, send it to a county auction, and sell it if before then they refuse to simply pay off the judgment. So if you've got somebody with assets, that's the procedure. You abstract your judgment, you record it, and then you request a writ of execution to attach that abstracted judgment to a specific property to be seized at county auction, the proceeds of which will go to your judgment. So let's see what has been added here. What is the rule as far as a security deposit if you do not want to renew and move in? Ms. Badil, there are a lot of rules having to do with security deposits. If it's a matter of a prepaid security deposit and the tenant refuses to move in, the landlord is probably required to seek out a new tenant, but if it takes him more than 30 days to find that new tenant, they can probably keep that deposit. Again, these issues are very fact specific and hard to digest, abstractly. But there's got to be a reason why the move-in doesn't occur. And if it's through no fault of the landlord, unfortunately, the security deposit might get waived. So Ian Glenn writes, I would like to give my tenants small shares of ownership in the property for on-time payment to give them positive reinforcement. Benefits of capitalism. Has anyone else done this? Ian, I've never heard of giving tenants ownership. And I would strongly discourage you from this for this very simple principle. Let's say I'm your tenant and we have an agreement. And I say, Ian, I would like to sign a 5-year lease with you. And you say, wow, how interesting. And you say, well, for every month, I'll give you 1/10 of 1% of ownership for the rent you pay. But you have to agree to pay $3,000 worth of rent. And I say, you know what? I'll take that deal. And sure enough, I pay you the first month of rent and you deed over to me 1/10 of 1%. Well, let's say I never pay rent again. Guess what you cannot do to me? You cannot evict an owner. And it doesn't matter that I only own 1/10 of 1%. If you deed any portion of ownership to me, I can never be evicted. This is not something I would ever recommend. You go on to write, only negative reinforcement breeds negative results. In my opinion, mostly looking for positive reinforcement instead of always give me the security deposit. And I get that. There are other ways to show positive reinforcement. In fact, presenting a stellar unit to a tenant is positive reinforcement. Maintaining a high quality unit for that tenant is positive reinforcement, assuring them that anytime anything goes wrong, you're going to be there to deliver excellent customer service. These are things that good landlords do all the time. And I think it is extremely positive to have a tenant who feels secure in the place that they're staying, even if they're exchanging money for it. Certainly, if you're paying money for a service and you feel like you're getting excellent service for it, you're likelier to continue to pay that money gladly because of the return that you're getting. But ownership like this is just not a good idea. It puts you actually, as the proprietor of this business, in a terrible, terrible position. So it wouldn't be something that I would suggest. Tiger Harris writes, wouldn't giving tenant ownership interest in property make it difficult to evict? Absolutely it would, and that was the point. It's not just difficult, it is impossible. You cannot be evicted if you are an owner, and it doesn't matter to what extent you own something. Any amount of ownership means you have an absolute right to occupy. So let's move on. Zoila Deros writes, from our newsletter, she wrote in response to our newsletter, if a tenant pays late one time and requests that the fee be forgiven, would it be okay to void the late fee one time only, even if there's a late fee on the lease agreement? This is a question that I talked about last night. I was at an event and this came up. And so what I tend to tell landlords is the following. If you've got a tenant who's got a long history of always paying on time, taking good care of the property, just being the top tier kind of tenant. They've renewed once, they renewed a second time, but something came up and they've got a problem. And you have every confidence that this is a one-time thing. They're gonna, it's not gonna affect anything else. Absolutely, it's good customer service. Just like I was talking with Ian here, it's good customer service to waive this. But if you've got somebody brand new, not somebody who's established a long history of on-time payment, good property management, well-manicured lawn, all these things, it's their second month and they're already paying late. No, I wouldn't suggest waiving that. In fact, it's important for you, particularly early on, particularly within the first 6 months, to enforce every provision of the lease. Because that first 6 months is going to tell you what you can expect in the last 6 months. And if it's been issue after issue after issue, you can expect more of the same in the last 6 months. And so that should inform you as to whether or not you're going to renew. Probably not. But if it gets bad enough, it's not just late payment, now it's non-payment, then you got to evict. But through enforcement, you're going to save yourself the most money and recover the property in the shortest amount of time to put it in the hands of a tenant who does care about the terms of the agreement and who can afford and is willing to uphold all of its terms. So that's my 2 cents on that particular question. Ian writes, I believe in capitalism. If they only have ownership, they feel connected to the property. Thank you for your response, though. I'll find a way. Well, good luck with that. Certainly, I believe in all sorts of creative ways of making this kind of thing works. But I don't know if ownership alone or ownership itself is the only way for them to feel connected, or that feeling connected to the property is necessarily the goal. The goal should be finding value in the service that you provide as a landlord, and if they find that as a high value, then they're likely to pay what it is that you agree to without complaint. So it's a trade-off, right? You deliver a good service, you can expect a good return. John Ramirez writes, interested in suing my HOA. They fine me all the time while renting property and was forced to sell it. Well, if their fines were based on the deed restrictions that you agreed to when you bought the property, you have zero grounds to sue your HOA. If the fines were improper, then why would you pay them? Let them sue you in court, put up your defense, and they would lose, and you could potentially recover your attorney's fees. But if you're saying, well, I had such terrible tenants that were constantly getting HOA fines, why were you paying them? This is just like repairs. You issue those to your tenants and demand, these got to get paid. You agreed in the lease to uphold the deed restrictions of the HOA, and you failed to do it. Now I'm getting letters with fines. These are your fines. Pay them or you got to go. And so the fact that the HOA is enforcing its deed restrictions means you also have to enforce your lease when tenants violate the lease and cause this kind of harm. So Bean Samuel writes, as a listing agent, I helped a homeowner with financial difficulties handle the cost of renovation, hoping to recoup my money when the property sells. Well, the problem is that the property was on the market for 4 months, no offers. He's facing eviction. He has a healthy amount of equity in the home. He wanted to terminate our listing, which I've done, and he promised to pay me back the money when he gets on his feet. How do I make sure I get my money back? I'm trying not to go the route of paying a lot of legal fees, but at the same time, I just can't take his word for it and trust that he will do the right thing. This sounds very much like the guy we talked about at the very beginning of this talk, that judgment-proof individual. If someone is in such a position that they're losing their house, it is very unlikely, highly unlikely, that they're going to be able to pay back any debt. Their credit's going to be in the tank. If they're losing their equity, either A, they're charging way too much to sell this property, or the property doesn't have the value that you're seeking for it in the sale. I mean, either it's underwater because too much is owed and there's not enough value for someone to invest in it, or there's something else going wrong here where they're unable to recover their equity. But the fact is, just loaning money like this was probably not the best idea. If you're going to extend a loan, and even if you had secured a promissory note and a deed of trust, the superior lien, if it gets foreclosed, washes out all inferior liens. And so you wouldn't have collected anyway, unless somebody came in and bought the house. So you pay off the superior lien, you pay off your little lien, and so at closing you would recover. But I mean, short of that, I just don't know how you're going to get your money from this individual who sounds like a judgment-proof party. I'm sorry to pass on such, bad news, but yeah, this is unfortunately just a terrible situation. Alexander Valentin writes, interesting idea, but offering ownership for on-time rent comes with serious risks: legal liability, tax issues, loss of control, potentially problems with your lender. I agree. TextMate says correct. I mean, it's just it's an interesting idea, and we're here just sharing ideas. But I don't know that I could recommend it as a good legal course. Tiger Harris writes, if landlord terminates commercial lease due to non-payment, what happens if they continue to accept rent after the termination date? Does an active lease become month to month? Yes. If you terminate and then accept money during what otherwise would be the holdover period, guess what? You've just created tasks, you've just agreed to another 30 days. And so, I always tell landlords, look, if you want them, keep taking their money. If you don't want them, tell them definitively, get out, and then don't take their money, because you make an implied promise that they get at least 30 days when you take that money, right? So absolutely, if you send a notice of termination and then accept money afterward, during that holdover period, you create that month-to-month tenancy. It's not a good idea. Ian continues, thanks for brainstorming with me. Maybe I can use the same loophole apps like Fundrise use. Maybe I give them shares in a company that gives insurance payouts based on the property value. Okay, sure, maybe. I'm not real sure how that is going to benefit everybody, but yay capitalism. Ibn Samuel writes, living in Houston, thank you. You're very welcome. You're very welcome. Again, sorry that I couldn't give you much better information here, but I mean, it is what it is. It's an expensive lesson. Raymond Nick writes, what's the best way to avoid tenant appealing the initial eviction in Dallas County? You can't restrict them from appealing. It is possible in some situations to have them waive their right to an appeal in certain agreements. But if they're going to appeal, they're going to appeal. Generally speaking, what I tell landlords is about 80% of tenants leave within the term of the justice court. Only about 20% actually appeal and actually stay a significant amount of time after that. So most tenants will leave during the first part, but you really can't prevent it, not adequately anyway, and not without some kind of agreement from the tenant. What you want to do is enforce the rules. And one of those rules is that they pay rent into the court's registry. If you don't know how to enforce that, because generally speaking, their failure to pay rent means you are entitled to a writ of possession, but you got to ask for it at the proper time, and you got to know how to enforce that right. So you might need to seek out counsel, and we represent people in Dallas County, so don't hesitate to give us a call if you find yourself in that situation. Ingrid Pino writes, I own a duplex and would like to raise the rent. I was wondering if there were any laws about the amount or percentage of increase you're allowed to make at one time or within the year. Like I said, if you're within the lease term, you've got a 12-month lease that started January 1st and ends December 31st. You cannot raise the rent during that time. But if you're beyond that term or approaching renewal, yes, you can propose as much of an increase as you want. There are zero limits. As long as you've given proper notice, the tenant has a proper remedy. They can walk, or they can say, I love it, I'm for it, I will pay that increase because this place rocks and I'm not leaving. That's the way it is. You give adequate notice and they can make an adult decision. If they don't mind the increase, by all means, whatever makes sense to you. But if they do, because they've gotten proper notice, they're not required to pay it, but they can't stay if they don't pay. Tammy Ray Lee says, when do I need to tell my renter that rent is going up and renewal contract? How far in advance? Well, I like to get ahead of it, way ahead of it. So understand what your lease requires. Some say 30 days of advance notice, some say 60 days. So don't flirt with those numbers. I would get ahead and maybe 90 days out, say, yeah, I'm interested in renewing, and here's what I'm looking at in terms of renewal. Here's a lease. That way, if they're wishy-washy on it on day 60 and they won't tell you, don't mess around. They're not thinking about you. They're thinking about other things and how to position themselves. You might at that point just have to cut them off and say, well, I tell you what, we're 60 days out. I'm going to rescind that offer for the renewal and just terminate. This way you maintain control and you're not left in limbo or left with some future promise. Oh, I'll get around to it. I'll get around to it. I'll get around to it. I just don't like that uncertainty. Give it to them about 30 days beyond what your lease requires for termination. Give them 2 or 3 weeks, but give them a cutoff date with enough time for you to hand over a notice of lease termination and a rescission of that prior offer. That's my recommendation. And here is the last question I've got here. Tiger Harris writes, Ernie, you are the landlord when it comes to evictions. All right, well, thank you. I appreciate that. I'm not actually a landlord myself. I'm a landlord attorney, but I don't mind being the landlord. That sounds great. Last question. Dominic Min Win writes, I have a fully furnished rental house. Recently, a temporary housing agency has contacted me to place a displaced family whose house was burned down. The insurance company is going to pay for the cost of their stay. There are multiple parties involved. The lease will be, the lessee will be the temporary agency. I'm already hearing alarm bells. The occupants will be the displaced family. My LLC, which I wholly own, will be the landlord. The insurance company will pay the temp agency, which then turns around and pays me after getting their cut. What should I look out for in this situation? I've asked to only do background check and not credit check. How should the lease be constructed? The real question is who's on the hook? What happens when things go wrong? What happens if the kitchen gets burned? What happens if rent goes unpaid? Who's going to get kicked out? And whose pocket are you going into? How much of a security deposit is going to be paid? Does your insurance allow this setup? There are a ton of considerations before I would ever agree to or before I would ever advise a landlord to agree to terms like this. There's a lot of questions here, a lot of what ifs. The fact is, this temporary housing agency, how long have they been in business? Is this a legitimate business? If you do a little research on the agency that's going to sign the lease, and you find that they started up in 2024, that's a terrible, terrible sign. Here's another thing. Do you know of any other landlord who signed a contract like this? Personally, I don't. And so because it doesn't happen often, it maybe sounds a little weird. And if it sounds a little weird, it probably is because it's a little fake. And so I tend to look at situations like this and say, scrutinize it deeply, consider every possible reason to run away from it, because I don't think you have to dig very deep before you find some kind of problem here. And so because of that, and here's an easy reason. Insurance can put people up in hotels. They can put people up in extended stay places that are set up for this kind of thing. Generally speaking, repairs on a house don't take 6 months. But if they do, they can tell the tenants to sign a lease for 6 months, and the insurance company will simply reimburse them those costs. With this third-party agency involved, I don't know. Sounds a little sus, and I don't know that I would trust it. Let's see. Texas Mate says, yikes, setting yourself up for failure. Ian adds, I really appreciate you doing this live chat and answering questions. For your information, Alex Valentin is AI. You can tell from him using long dash. That is no keyboard key, unlike real people using normal dash. Well, I appreciate that. I know sometimes I write my my entries somewhere else and move them over for grammar and spelling and stuff like that. So I don't know if that's necessarily AI. I know for sure he's AV because those are his initials. But thanks for your insight. Christine Robalino writes, most of the tenants who leave owing rent are judgment proof. I don't know about most, but many are for sure. Just write it off and move on. Never rent to Section 8 or HUD. Sorry, not sorry. That's also one that I've heard, some landlords swear by Section 8. And when you know how to do it, you can do it really well. And so I don't ever say absolutely don't ever do this, or definitely never do this, or always do this, or you must do that, because there are always exceptions. But I am done with my questions. We went a little bit long, an hour and 15 this time. I want to thank all of you who stuck around to the end. For those of you who missed the beginning, we'll definitely have a replay, and I look forward to you checking stuff out there. James Wright, thank you for your time, Ernie. James, you are very welcome. I appreciate you coming out here all the time. I will be back next Wednesday, barring any kind of court proceeding that calls me at the last second. Otherwise, you'll see me here at 4 o'clock Houston time next Wednesday. We'll be back. Thank you all for joining. And until next time, landlords, happy leasing.